Good morning, everyone. I'm reminded that the last time I spoke in front of a group this large, and I do a fair amount of speaking in my capacity, but the last time I spoke to a group this large was the Pennsylvania School Board Solicitors Association Summer Symposium, and we had about 250 or 300 school solicitors, and it was my job to teach them an hour of ethics. Imagine teaching 300 lawyers ethics. This is going to be a walk in the park. But you can see, I suppose I should probably put my PowerPoint up. Topic is going to be student records and privacy and security concerns in the electronic age. That's a little bit frightening. And I've been told when I give presentations to various school groups, and I do a little bit of in-service training to the various school districts that I represent as well, people walk away afraid. That's not really my intent, but I do have that effect. And I suspect that there are going to be some of you who are going to walk away with that same feeling today. And if I have tweaked a nerve, well, maybe that's a good thing. I'm scheduled for 2 hours, and I've got 84 slides. That means they're going to go pretty fast. But you know, if you have any questions, I think are we passing questions around somehow? Note cards. There'll be note cards, so you can pass questions around, and I'll try to get to them if I haven't already pre-planned it in my presentation. We're going to start where I think our policies at the IU require us to start, and that is with the IU policies on student records. If you look at those policies, you'll see that we are supposed to have training on them. Welcome to the training. Our policies begin with the Student Records Policy 216, and you heard Dr. Johnson talk about FERPA, the Family Educational Rights and Privacy Act, federal law. This policy mirrors the requirements of FERPA. So it governs the collection, maintenance, and dissemination of student records. And when we talk about that, we're going to talk about records and how they get disclosed. And I'll give you a little spoiler alert. I have spoiler alerts sprinkled throughout here, but we maintain records in paper format, in electronic format. That doesn't mean dissemination is limited to distributing the paper or transmitting the electronic format. It can include oral communication of the record. And that's the first thing that I need to have you thinking about is when you're talking about student records, who are you talking to and where are you? And we'll get to that later. All right, Policy 216 also talks about safeguarding or protecting those records. And in the electronic age, that's a bit of a challenge. So we're going to talk about that. Procedures that allow parents, in the FERPA law itself actually talks about the rights of parents to inspect the records, to copy their records, to ask you to remove records, and there's actually challenge hearings that are provided for in there. We also define what's directory information. That's information you can share without getting the consent of a parent. Okay? And we're going to talk about legitimate educational interest, which is defined in your policy. If you haven't looked at Policy 216 and some of the other policies that I'm going to be referring to, you probably ought to at least go through the policy manual and take a look at those if you're dealing with student records. And I have a short guess that most of you here in the room deal with them on some basis at some level. This is what we call directory information in our policy. And I wanted to highlight some of the things that are part of directory information. One of them that I wanted to point out to you is photograph. And the reason I wanted to point out a photograph is that can be problematic in the electronic age. Under the Children's Online Privacy Protection Act, there are certain requirements that you have with regard to obtaining parental consent for displaying images of students online if they're under the age of 13. So you need to have, and I deal a lot with actually the Erie Diocesan schools, and they do a lot of marketing for enrollment purposes. And so we'd spend an awful lot of time talking about, well, can I post this of kids doing certain activities? The answer is that you can, depending upon their age and if you in fact get consent. But the other thing that we have to be concerned about, and we're going to talk about this later today, is child custody issues. Because there are often, and it's unfortunate today, that we have disintegrated families, parents that are separated, and parents that are actually hiding from their former spouses. So we've got to be careful of what's available online that a parent may not want to have online. I actually had an occasion with one of my districts where, out of the blue, an investigator showed up from Alabama and said, I want to take 2 kids. Okay, imagine they found the students. The students were actually from a family that had separated in Alabama, and one of the spouses had moved to my district and brought their kids with them, and they were literally hiding. There's a statute called the Uniform Child Custody Jurisdiction Act that requires that the jurisdiction for child custody disputes rests with the state in which the child has resided for the last, for at least 6 months. Fortunately, they'd managed to hide long enough that jurisdiction was in Pennsylvania, and I wouldn't let the kids go without a court order from a Pennsylvania judge. But those are the types of things that, boy, they didn't teach you that in law school. They didn't teach you that when you were in college and learning to be an educator or an education specialist of some kind. But now we're dealing with that. And the one thing that you have to remember about directory information is the ability of the parent to opt out. If I say all of these things are directory information, the parent has the ability to come in and say, oh no, it's not for the case of my child, okay? You are not to disclose any of this information without my consent. Now that's a problem for us because we're a regional educational agency that serves school districts, public and private. And a lot of these parents deal directly with their school district. So the question we've got to ask ourselves in dealing with our kids is, have they opted out in their local district? Okay. So that's a question you got to put in the back of your head. Okay. Most of the issues regarding FERPA directory information, opt-out, record challenges, and those things are going to be handled by the local districts, but we do have some IU students, so we may have to deal with this ourselves. Here's some things that aren't directory information, and some red flags ought to go up immediately because Social Security numbers are not included in directory information, and there are some programs that we operate at the IU in which you must use Social Security numbers. We're going to talk about that a little bit later. Even the student IDs, and incidentally the Federal Department of Education encourages us to use ID numbers that are not Social Security numbers for the purposes of maintaining student records. One thing that we're going to talk about a little bit later is personally identifiable information, and that's what we're dealing with when we talk about directory information, but it includes linkable information. Linkable is, it may not identify the student per se, but a reasonable person, not Vince, who's an electronic guru, but a reasonable person could link that information to a particular child. So we've got to be very careful about what student IDs and what information might be linkable to an individual. So who has rights to control the educational record? That's an interesting and open question because there's some conflict in the law. Parents, certainly under FERPA, have the right to control student records, but that term is defined in the statute, and it includes a natural parent, a guardian, a person acting as a parent in the absence of a parent or guardian, unless that person has had an involuntary termination of their parental rights. That's different than the definition under IDEA. So if you're looking at the Individuals with Disabilities Education Act and you want to know who has educational rights there, it includes people that aren't on this list. It includes step-parents, which aren't on this list. It includes grandparents, which is not on this list. Neither one of them includes significant others. So, and I've had this case where a parent, a divorced couple, and we invite them to an IEP. Dad can't come, he's going to be at work that day, but he wants to send his girlfriend to sit in at the IEP meeting. If you look at the definition under the IDEA, girlfriend can't sit in at the IEP meeting. Okay? So we've got to be careful who has the rights, and they're going to be different depending on what we're talking about. FERPA is more limiting than the IDEA in this regard. There's a lot of confusion about eligible students. Under FERPA, the rights to control your records transfer at age 18. Under IDEA, they don't. Under IDEA, they transfer at the age of majority for the state in which you reside. In Pennsylvania, that's 21. But let's talk about FERPA for a minute. Anybody, you don't have to raise your hands. College-age students, how many of your college students get their grades sent directly to them and they don't share them with you? 2 kids. They did all right. That's not what FERPA says. FERPA says that a student attaining age 18 or attending a post-secondary education is entitled to control their records in lieu of the parent. And there's that big unless there. I didn't underline that, I probably should have. Unless the eligible student is dependent on the parents as defined in the Internal Revenue Code, IRC, Internal Revenue Code. Have you declared your student to be a dependent on your federal income tax return? Ask for their grades. Okay, I mentioned this already. IDEA is different. It does include the step-parents and grandparents, so we've got that right, and we've already covered the age of majority. See, we're going through this pretty fast. Policy 216.1 are the discipline records, and we're not going to have a lot of those, but we have a policy on it and how we maintain them and who we can share them with. We're allowed to share those records with a district that is receiving the student by way of transfer. We have to share them with the Juvenile Probation Office. That's what I mean by JPO. If there's another district that you're sending them to, you can share them with people who have a legitimate educational interest. I show up there, the program supervisor may share with the student's teacher, principal, other people that are going to be needing to know about those records. And some of those records are going to deal with, unfortunately, weapons charges, alcohol and drug cases, where it will be prejudicial to the student if more people know it than need to know it. So you have to be careful about what discipline records you're showing. You should also be familiar with Policy 113.4 and the confidentiality of special education student records. We've already talked about FERPA. We know what limitations we have. I've identified personally identifiable information as any information that is linked to a student or is linkable to a student. One of the things that we have to do, and for those of you who are doing the clerical support functions, we have to keep an access log of who, when, and the purpose in which a student record was accessed. We can exclude from keeping that log for a parent that accesses the record or for any authorized IU employees who are accessing the record. Other than those who are authorized to do so, however, you have to keep that log. Second spoiler alert of the morning, if we have a data breach for an electronic record, we're going to log that as access to the student record. Okay? And we're going to talk about what data breaches are. Our policy requires us to keep records for 6 years and to notify the parent when we're no longer going to require that personally identifiable information. If you look at the IDEA, it will tell you that you have to maintain, well, there's a statute of limitations for claims, and it's 2 years. So when we deal with compensatory ed claims and special ed and all those things, it's a look-back period for 2 years. So generally, from my standpoint, I say 2 years from the time the student turns age 21 is the absolute limit for which we probably have a claim. There are statutes of limitations for contract claims in Pennsylvania that go as long as 6 years, which is why we have the 6-year statute in there. There's also some rumblings about some case law that may change the statute of limitations for IDEA claims. The 2-year limitation is Pennsylvania. In other states, it's longer, and they're trying to bring that longer statute here. So our policy requires those to be maintained for 6 years. You'll see that policy requires parental consent for the disclosure of those records, and it's required before releasing the information to any participating agencies in transition services. So if we're not doing transition services within the IU staff itself and we have outside agencies participating, we need the consent of the parent to have those records transmitted. And of course, the last bullet point is why we're here this morning. We're training on board policy on disclosure of student records. Other policies with which you should be familiar include the special ed policies itself, 113, which we define parent to include the parent definition under the IDEA, including the adoptive parent, including the step parent. Policy 113.5 on early intervention has the same definition for parents and guardians. So if you're involved in that program, you should be familiar with that policy as well. And of course, those policies and all the policies we talk about require us to maintain student educational records and personally identifiable information about students confidentially. So the question is, are we doing that? So let's look at the FERPA requirements. I've mentioned what the statute says. FERPA tells us what is and is not an educational record. It tells us when consent is required and when it's not required. The good news for us today is that FERPA has no private cause of action for a violation, which means the parent can't sue the IU for a data breach or improper disclosure. The Family Policy Compliance Office within the Office of Civil Rights enforces FERPA, and a violation can result in the loss of federal funds. And I always get asked this question when we're talking to school district clients. Well, what's that mean? Our federal budget's 1% of our overall budget, 2% of our overall budget. I looked at the 2016-17 IU budget, and the federal programs portion of the budget is 31%. So the loss of federal funds to the IU is significant if that would come to fruition. Now, I have to say in full disclosure, and we're talking about transgender issues separately, and we know about all the lawsuits that the states have filed about enforcement of the bathroom issue, for example, and they talk, and there's a lot of threats going around about loss of federal funds. The federal government has indicated in the transgender issues, at least, that they're not interested in seeking the loss of federal funds by the local districts that fail to comply. They're interested in compliance, and I think the same holds true with regard to violations of disclosure of student records. They're not really interested in taking away federal funds. They're interested in compliance. So if they find a violation, they're going to call you on it the first time. They're going to call you on it and say, rewrite your policies. They'll have you enter a consent order and agreement and rewrite your policies, train your staff. The second time, not so nice, okay? Once they find that they've got egregious violations where people just don't get it, then they're going to start talking money. Third spoiler alert of the morning, there are currently pending in Congress a number of FERPA amendments. Some of those amendments will correct this little loophole, I suppose, and give the ability of the government to obtain fines for noncompliance and other penalties that may make it more interesting for people to comply. So, what do we mean by educational record? We mean a record that's directly related to a student. That makes sense. Maintained by an educational agency or institution or a party acting for the agency or institution. That's right out of the statute. That makes sense. So, for the teachers in the room, educational records do not include records that are kept in the sole possession of the maker. You're entitled to have anecdotal records on your student that you share with no one. Therefore, your use, or, if you're absent, for your substitute. Nobody else. If you have a sole possession record, and you do happen to share it with somebody else, it now becomes an educational record. Sole possession means sole possession, okay? Keep that in mind, okay? If the buildings, if the district in which you are working or have a school police officer or a school resource officer, records of those individuals are not part of the educational record and they need to be maintained separately. If we have a student that's employed, employment records are not part of the educational record, and those other exceptions are actually really in there for post-secondary because FERPA does apply to college students. And of course, number 6 was added after the Suaso versus Falvo case about students grading each other's papers. That was 15 years ago now. So, release of educational records. This is what the statute says. No funds, that's federal funds, shall be made available under any applicable program to any agency that has a policy or practice. I underline in my notes, or practice, okay? Because policy is one thing. What you do might be different. I hope not. But or practice of permitting the release of educational records or personally identifiable information, other than that directory information we talked about, without consent. So the real question comes back to these electronic records and data breaches. Do we have adequate security in place? Are we, and this is the catchphrase for the case law, indifferent to the release of records such that it would be considered a practice of permitting the release without consent? That's why the security of the student records is so important. What do we mean by release? It means permitting access or transfer, and it means oral, written, or electronic means. Now, I've had these cases, and I've discussed it. I apologize if any of you have been to any of my other seminars on FERPA. I've had some rather horror stories about these things. You would think that discussing a student in the faculty lounge would be a safe haven, wouldn't you? I actually had, this is an actual case. I had a terror as a student. It was about, I think he was a sophomore. Very bad individual. Teachers were absolutely exasperated, and they found themselves in the faculty lounge, and they were just commiserating about how this kid was acting up and what they were going to do about it. There was a substitute teacher in the building that day, and the substitute teacher also happened to be in the faculty lounge. As luck would have it, the substitute teacher was the mother of this student. That's the reaction I wanted, see? Yeah, I mentioned the phrase legitimate educational interest, okay? These teachers, let's assume that they both had a legitimate educational interest in discussing that student. Did they have the interest in discussing it in front of somebody who didn't, or whom they should presume didn't have an educational interest? And the mother complained. I had another example. On a weekend, in a grocery store, two teachers, both with educational interests in the particular student, talking in a grocery aisle. What they didn't know was that mom was in the next aisle shopping. So we heard that complaint as well. So you need to be careful about the release. When I say an educational record, you might think of a piece of paper. You might think of a flash drive. Educational records can come out of your mouth. Okay? And that's a release of information. And if it doesn't meet one of the exceptions for FERPA, you need parental consent to disclose it. So be careful. Release is a broad term. So what does consent mean? Consent is a signed and dated written consent. So we can't call mom and dad on the phone and say, hey, can I give these records away? You have to specify what records you want to disclose. You want to state the purpose for which the disclosure is being made and identify to whom the records will be disclosed. The parents may request that you send them a copy of what you are going to disclose. So the question I have, don't raise your hands. Are our consents to the disclosure of student educational records compliant with FERPA? Are we getting written consents when we need them? Are we specifying what's being disclosed and the purpose and to whom? That's what FERPA requires. The good news is that consent is not always required. And the really good news is there's a whole lot of exceptions that kind of swallow the rule. There are 15 exceptions in FERPA, and the first one, and we've already talked about it, is disclosure to school officials with legitimate educational interests. The nice thing for us is that they amended FERPA a couple years ago so that contractors and consultants and volunteers even meet the definition of school officials. So we can disclose, and we're going to talk about some online software programs that we might use in our classrooms, and contracting with those software vendors. They may in fact be school officials. In fact, they designate themselves as school officials in many cases. We must, however, if we think that there's a legitimate educational interest in disclosing those records to a school official, we have to use reasonable methods to make sure that they do have a legitimate educational interest. Now, the last bullet point is the one I really wanted to highlight here, and this comes right out of the statute as well. If we do not have, or we do not use physical technology, locked file drawers, locked student record rooms, or technological access controls, password protection, encryption, we must ensure that we have an administrative policy for controlling access that is effective. Not that we have one, but one that is effective. So we have to ensure the protection of those records in physical form and electronic form. Okay. I'm going to go quickly through the list of what's not required. When we disclose to officials of another school district, if a student's going to transfer from Erie to Mill Creek, for example, and they're transferring from one of our programs to another of our programs, we can transfer records. We don't need consent for that. We can provide records to state and federal and local officials. Department of Education, Auditor General, things of that nature. Don't require consent for that. Juvenile justice gets a break. We don't have to tell the parents we're disclosing those records to them either. Anybody that's doing educational studies, and there's a lot of those, and IU records are often sought for those purposes of study, we can share those records. Those individuals with whom the records are shared, however, have the same obligations to maintain the personally identifiable information confidentially. Accrediting agencies. Parents of a dependent student. This is the Internal Revenue Code reference that I made earlier. We're going to talk a little bit later about subpoenas and judicial court orders for the disclosure of information. You can disclose information in connection with a health or safety emergency. That goes both ways. It can be information for a student that may have a health impairment. We've had these issues. Molly's called me about Diastat, and administering Diastat on a bus, I think, or on a field trip. I mean, these things, I love my phone calls. Anyway, we can disclose health information on a student in the case of a student emergency. We can also disclose health information if the student presents a health or emergency situation to others because of their situation. So it can work both ways, but the case law that's developed under this exception says that we have to have an immediate emergency. We can't disclose information that might be necessary later. We have to have an impending crisis. I'm not sure exactly why that helps anybody, but that's the case law. So be aware of that, and disclosure is limited only for the period of that actual emergency. Some of these other exceptions really deal with post-secondary education, students that are away at college or some post-secondary institution and are arrested for drug and alcohol violations, that are arrested for sexual assault on other students on campus, things of that nature. Again, FERPA covers high school, elementary, secondary, and post-secondary. We've danced around the issue of legitimate educational interest for a while, so let's talk about that. And the very first bullet point is, it's not defined. What a wonderful thing for the federal government to tell us that we have to have a legitimate educational interest and not tell us what that is. What the regulations seem to suggest is that a school official may have a legitimate educational interest if they're a teacher, a principal, board member, counselor, admissions officer. I get a pass on that as an attorney, accountants, and human resource professionals, but not all of those people. I mean, if I said teacher, if I said principal, I could talk about anybody in the district, any program supervisor in the IU. That's not what we mean. We still mean those people can have a legitimate educational interest, but not all of them do, okay? We may outsource some of our programming to contractors or consultants. Those people can be considered school officials, but only while they're performing the services that we ask them to do, and not for other reasons. So they may have a limited legitimate educational interest, and we have to be careful about what we're disclosing, how much we're disclosing, and things of that nature. I wish I had a better answer to legitimate educational interest, and here's my, I guess, my practical solution to you for now. If in the course of your job responsibilities, you interact with this student either as a direct caregiver, instructor, service provider, If you supervise someone who does, if you have in the past provided services for this student and you are consulted on what are best practices, what works for this particular student, I think you probably have a legitimate educational interest in discussing that with current providers. If you are a professional or non-professional for that matter in the building, you probably don't have a legitimate educational interest in knowing a lot about that kid. If a student has, well, let's just say tepilepsy, for example, do we have to tell the entire building? No. Do we have to tell the teachers or the staff that monitor the lunchroom? Maybe. Do we have to tell the person that's monitoring recess? Maybe. Do we have to tell the bus driver? Probably not if there's a nurse on the bus. So we have to, it's a case by case, and I guess that's why the federal government in its infinite wisdom decided not to define it, because it's going to be different in so many different situations. But I think you have to ask yourself, why am I discussing this student with this person? Why am I sharing this information in paper form or electronic form with this individual? Is there some reason they need this? Or is there some information I need from them that they need to have this information to provide back to me? If you can't answer that question in the affirmative, that they have an interest in that information, then you probably shouldn't be giving it to them without the consent. Okay? So that's just a bit of practical advice to fill the void. Judicial orders and subpoenas. I'm not a domestic relations lawyer. I did one case as a young lawyer and found that it was totally distasteful to me. But 50% of marriages end in divorce. A lot of those divorces involve children, a lot of them involve child custody issues, and some of them become acrimonious. It's becoming more and more the case that parents will seek out school officials to testify about how good they are as parents or how bad their ex-partner was as a parent. And they usually do that by having their attorney send you a subpoena out of the blue, and you say, oh my God, what do I do? Okay. FERPA answers that question for us, fortunately. Educational agencies must, this is different than trial by surprise, we have to tell the parent or other individual acting as a parent that you received a subpoena to testify so that they can go into court and try to what we call quash it, make it go away, okay? So you don't have to be there. The other thing that generally we do is get me involved at this point, and the Bar Association in the Tri-County area is small enough, I know most of the people, and I'll call them on the phone and say, what do you need, teacher A, or what do you need our occupational therapist for? And we want them to testify, blah, 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 blah. I said, can we give you the records? Can you get us a release for the records? And then I tell them point blank, we do not take sides. This is, I'm old. Dragnet, anybody? Okay. Just the facts, ma'am, okay? We do not give opinions. I've had people ask our staff in the course of a child custody case whether the parent, a custodial parent, is literally a bad parent. Is the child coming in to the classroom sleep deprived? Are they coming in the same clothes they were wearing yesterday? Did they bathe? Those are the types of questions that, at some level are going to require you to render an opinion. Now, many of you are experts on educational matters. I'm not sure if you're experts on other things, such as good parenting skills. They may be different than your own, but I don't want you rendering opinions in favor of one side or the other in a custody dispute. That's not our job. So I always tell you, and take it down the middle. Just the facts. Johnny's grades slipped in the last quarter. Here's a copy of his mid-quarter report. He's absent more frequently. Those things you can say. But beyond that, I don't want you on the stand saying, I really think he was doing better with Mom. That's really not our role. That's really for the judge to decide. So try to stay out of those. I'm going to try to get you out of subpoenas as often as I can by supplying records. Sometimes you have to show up, and in those cases, I'll, with authorization, I'll go with you. So we can avoid that type of thing. But you always have to let the other side know that you got a subpoena so they can go in and try to get you out of it themselves. 3 exceptions are up there for when you cannot disclose. And I'm not going to go into those. If you get a subpoena from one of those agencies, I'm sure somebody's going to call me. We're allowed to disclose information. If the parent sues us, we can share information with the court. We don't need consent of the parent. If we go to a due process hearing, we can share that information as well without going to court. If we initiate a lawsuit, and there are instances where school districts and even the intermediate unit would initiate a due process hearing, or although less frequently, the old Honig injunction hearings to have a student removed for disruptive behavior, where we're the initiating party, we can still disclose information without getting consent. So at least we have that in our pocket. I mentioned that there's no private cause of action for FERPA violations. The parent can file a written complaint with the Family Policy Compliance Office within 180 days. So you can start ticking those days off. There is a discovery rule, which means that once the parent knows that there was a violation, the 180 days starts ticking. So if we don't disclose that, then it's 180 days from the discovery. So let's talk about the FERPA amendments. This is what's in Congress right now. Don't know if any of them are going to become law. I don't know when any of them might become law if they do. One is a complete FERPA overhaul. And it would update the definitions, and you can see that that overhaul includes the ability of the United States Department of Education to impose fines for violations. The surgical fix option really deals with the security issue, and it really is geared toward the recognition that we're doing a lot more electronically than in the past. The transparency requirement is really to notify parents of our security and privacy policies, our actions that we would take with regard to contracts with vendors, including posting those policies online. So some of the surgical fixes, and there are various iterations of that in Congress, one of them would even require, read that unfunded mandate, require the school districts or school entities to appoint a chief privacy officer. Some of the other proposals include restrictions on when we collect what we collect and when we have to disclose to parents. Currently, we have 45 days to give them stuff when they ask for it. They would reduce that. There's the Child Online Privacy Protection Update for contractors, again, because of the electronic nature of many of our records these days. And there are provisions for the Safe Kids Act, again relating to online vendors, and targeted ads. We're going to talk about mining student data a little bit later. So this dovetails very nicely with what the federal government's talking about. There are several states who are really ahead of the curve here, and if you are so inclined to go online, I would encourage you to visit the Department of Education websites for Wisconsin, California, and Georgia, which have model statutes on all of these things that the federal government's currently looking at. It may be something that we want to look at as an IU and being proactive in some of the things that we do. These statutes talk about electronic records, transmission, the security that's going to be required, data breaches and the like. So it's very timely to look at those statutes. Before we talk about electronic records and data breaches, we're going to talk about the difference between FERPA and HIPAA. We may have HIPAA issues in the IU because of some of the programs we operate, but essentially, and this is my next spoiler alert, FERPA trumps HIPAA in our setting. So that's one of your takeaways is, when in doubt, look at FERPA first. But as I mentioned, FERPA prevents the disclosure of personally identifiable information in a student educational record without consent, subject to those 15 exceptions I gave you earlier. HIPAA, which is the Health Insurance Portability and Accountability Act, prevents covered entities, which is a defined term, from disclosing personally identifiable information to third parties unless authorized in writing. Covered entity is a health plan, read that, UPMC, Highmark, U.S. Healthcare, things of that nature. Healthcare clearinghouses, healthcare providers. Now, it's possible for the IU to be a healthcare provider for some of the programs that we operate. Even if we're not a covered entity, we may be a hybrid organization, which is a composite between a covered entity and a business associate. Or we may in fact be a business associate which performs certain functions for a covered entity. So if we have a contract to perform certain medical services as part of our programs, we may in fact be a business associate and have to enter into certain business associate agreements. But in the debate between FERPA and HIPAA, student health records, immunization information, et cetera, are considered to be educational records, not medical records. Protected health information is protected by HIPAA when it's being transmitted electronically or in any other form or media to a covered entity. And educational records are excluded from the definition of protected health information. So programs like access billing may have certain impacts or certain interactions with HIPAA, and we may be in fact covered by the HIPAA transactions and code sets for those types of programs. But we're not going to be subject to the HIPAA privacy rules. We're going to be covered by FERPA, and that's whether we're handling the health information, and primarily I think what we do is we're involved in the treatment aspect in our programs. So we might be a covered entity, we might be a business associate, we might be a hybrid, but the privacy rule doesn't require us to obtain consent for treatment, for payment, so when we're doing access billing, that's covered without consent, or healthcare activities, which are our assessments and our evaluations. So literally, even if the privacy rule applied, which I don't think it does, we would be able to transmit that information without consent. We can also share with various health agencies de-identified information, and they often like that, again, for survey purposes. We should be aware that there are actually mental health situations where students have rights to their medical records to the exclusion of parents. Under the HIPAA privacy rule, healthcare providers can treat the student as the individual that they discuss things with, rather than the parent as a personal representative. If the student is the person that has the right to consent, and that can exist in mental health situations, when the parent or when the minor obtains medical information without the consent of the parent, they can be the individual with whom the healthcare individual works. And when the parents accede in a confidentiality agreement to work directly with the minor. So there are situations where the parents might not even be aware that healthcare is being provided to their son or daughter, and that privacy rule would be in place and prevent them from accessing that information. So where are FERPA and HIPAA similar and different? Both of them provide general access to records. Both of them require written authorization for release. Both provide exceptions that allow release without consent, most of which swallow the rule. The differences, for our purposes, are the parent access rules, which are more limited in the HIPAA situation than the FERPA situation. It then affects who can sign the consent or the authorization, again, broader in FERPA than HIPAA, and who may exchange information without consent, again, more broad in the FERPA situation than the HIPAA situation. So, as I mentioned, I have 6 rules of privacy, and the very first one was the spoiler I gave you. Well, actually not the first one. FERPA never applies to non-students. That seems to make sense. FERPA only applies to student medical when student records are released. FERPA trumps HIPAA. HIPAA does not apply to records covered by FERPA. Even if you treat non-students, and I'm not sure that there's any situation, I'd probably look to Molly, if we ever treat non-students, we're not bound by HIPAA even in that situation unless we're transmitting records in electronic format in connection with payments of claims. So the takeaway you can, from the 6 rules of privacy, for our purposes, HIPAA applies, or excuse me, FERPA applies, not HIPAA. I mentioned there's a slide there that tells us how parents or students can complain about violations of HIPAA. There are money damages available for HIPAA violations, unlike FERPA, but we don't really care about that. In 99.9% of the cases, we're not going to be dealing with HIPAA. So you can probably forget that acronym for the time being.